Today we're going to revisit the topic of the POST Act, the Public Oversight and Police Technology. The reason why that's important is because the New York City Police Department sets the standard not only for police departments around this country, but around the world. And they sell that technology. So we need to be able to have oversight so the people can live free in America and be protected against all those entities that are gathering information on them.
Thank you for allowing me to speak this evening in support of the POST Act. My name is Nathan Sheard. I am the Associate Director of Community Organizing for the Electronic Frontier Foundation. I'm an activist and I'm a black man from New York City. Living at the intersection of these realities has provided me with a first-hand intimacy with the benefits that new technologies can bring to our lives, as well as the real-life consequences that these technologies can impose if their acquisition and use are not well thought out. I'm proud of being a New Yorker. I am proud of the city's contribution to art, culture, and centuries of political discourse. I am also troubled by our city's history of targeted surveillance of those that would speak truth to power and already marginalized communities. Technology has the power to improve our lives. It can make our government more accountable and more efficient and expose us to new information. But it has also been used to intrude on our privacy and chill our free speech. Every technology used for government surveillance raises a thicket of difficult questions. Should it be adopted at all? What are the benefits and the costs? If it is adopted, who will be targeted? And will it actually make us safer? The maintenance of a democratic society requires an informed public. Finding the most responsible answer to these questions requires an opportunity for our most trusted leaders and experts to engage in the dialogue. When all concerned stakeholders participate, we make better decisions. Oakland, San Francisco, Seattle, Nashville, Cambridge. These are just a few of the cities across the US that have already passed more robust legislation that responsibly balances public safety, privacy, and the civil liberties concerns implicated by surveillance technology, empowering their elected city council representatives to make critical decisions regarding privacy-invasive technology. While the POST Act stops short of empowering the people's representatives with this authority, it takes a critical first step by bringing the policies and technologies intended to protect New Yorkers' rights and safety out of the shadows and creating an opportunity for the public and experts beyond those working for the vendors to be heard in the development of these policies. Public safety requires trust between law enforcement and the community served. To ensure that trust, we need a transparent and informed process. The POST Act provides that process. On behalf of myself, my family, and other marginalized and targeted New Yorkers, and the Electronic Frontier Foundation, I ask you to support this crucial legislation.
Good evening, council members of the Committee on Public Safety. My name is Genevieve Fried, and I'm a technology fellow at the AI Now Institute, an interdisciplinary research institute at New York University that focuses on the social implications of artificial intelligence. AI Now respectfully submits the following testimony on Intro 0487, the POST Act. During the 2017 Public Safety Committee hearing on this bill, and as well today, the NYPD suggested that compliance with the POST Act requirements could allow adversaries to game and subvert NYPD's surveillance technology, putting New Yorkers' public safety at risk. As a computer scientist by training with a background in the development and deployment of the machine learning and data-driven systems that drive surveillance technology, I submit the following testimony today with two goals. One, to assure the committee that the NYPD's claims are unfounded because the public disclosure requirements in the POST Act do not present a risk to public safety, and two, that the POST Act is a necessary policy intervention because it provides a meaningful increase in transparency that will help promote democratic oversight and build trust between the NYPD and the communities it serves. For the brevity of time, my oral testimony will primarily focus on the first point. Concerns that the POST Act poses a risk to public safety are unwarranted. The POST Act requires a relatively modest level of public disclosure that provides valuable insight to the public, but is not sufficiently detailed for someone to game the system and threaten public safety. To game a surveillance system, one would need to know far more granular detail about it. At a minimum, one would need to know the specific data and data sets it uses as inputs, the systems or algorithms used to parse that data, the outputs presented by those algorithms, the strategies by which the surveillance systems are deployed, and how those strategies are implemented in practice. This type of disclosure would almost certainly include schematics, design documents, and often direct access to source code and the algorithms at issue. Moreover, given that many policing technologies are not actually applied in ways that are expected or desired, even knowing the strategies behind surveillance technology does not necessarily allow for gaming of that technology as operationalized by a specific agency. One would also need to know how the surveillance tool interacts with other tools that are being used and how the NYPD uses surveillance tools in connection with specific investigations or types of investigations. The Post Act does not require any of this information to be disclosed. Far from revealing the precise manner in which someone might evade or defeat the surveillance tool, the Post Act only admits that a system is in use, which bodies have access to this system, and whether there are policies or practices in place to regulate the retention, access, and use of data. We know that this type of public disclosure does not impede the efficacy of a given surveillance tool. For example, wiretaps remain a powerful investigative tool despite widespread public knowledge of their existence and the rules governing their use. Since the NYPD's statement on risk to public safety in 2017 and today, numerous other municipalities across the country have adopted ordinances mandating publication of far more information on surveillance technology and require far more civilian oversight of police surveillance. Though public safety concerns were raised during the deliberations of these ordinances, each measure passed unanimously or near unanimously and now provide the public with far more information than the Post Act requires. To date, there's been no evidence that the public disclosure required by these ordinances has resulted in any public safety threats. A loss of privacy and a lack of democratic input are not the inevitable outcomes of new technology. It is up to bodies such as the New York City Council to ensure that technological innovation is grounded within public transparency and accountability. The Post Act provides a necessary measure of public disclosure to New York City residents about how they are being surveilled without posing a public security risk. This type of transparency is necessary for a robust discourse about the social utility of surveillance technology. Thank you for your time.
Thank you.
Good evening, Chairperson Richards and council members. Thank you for the opportunity to submit this testimony on the importance of public oversight of surveillance technology. Our names are Ananya and Kiana, and we're speaking on behalf of the Youth Justice Board. The Youth Justice Board trains New York City youth in research and public policy and gives young people a voice in public policies that affect our lives. During the current program cycle, which runs through summer 2020, we're focusing on the intersection of digital surveillance and privacy of teens in New York City and interactions with the criminal legal system.
During our research process, we looked primarily at the relationship between youth actions on social media and systemic consequences. To do this, we conducted interviews with 23 experts and practitioners, led 2 focus groups with young people who have had personal experience with systemic consequences for online actions, and read hundreds of news and journal articles on surveillance, data management, and data ethics. We're here to testify about the importance of public oversight of surveillance technology to youth of color. We believe that our community is one most impacted by surveillance.
Growing up in a post-9/11 society, we have experienced an increase in surveillance and justification for why that surveillance is necessary. Constant developments in technology have allowed for surveillance to be executed more quickly and to impact larger communities at once. Our research has highlighted social media as a surveillance tactic used by law enforcement. Recent examples include the monitoring of Black Lives Matter protesters through hashtags and geotagging, as well as the use of social media to place youth of color on the NYPD criminal group database, commonly known as the gang database. For example, we heard about the death of a beloved community member who was believed to be gang affiliated. In honor of them, members of the community posted social media with the hashtag E4R, which means everything for, followed by the first initial of the person's name. NYPD was monitoring that hashtag and labeled members of the community as gang affiliated. Those people were then added to the database.
If NYPD shares database information with third parties, such as district attorneys or federal prosecutors, an individual may face a higher sentence, higher bail, or no bail options at all, fewer plea options or conspiracy charges, or any mix of those. If any of those community members get arrested for any reason, they may face any or all of those consequences because they posted about an alleged gang member on social media. They posted to feel like part of a community, which is a major reason any of us use social media at all.
In addition to interpersonal relationships, our generation uses social media for entertainment and self-education. We also try to use these platforms as a tool for finding, organizing, and improving our communities, like queer youth of color, immigrant youth, disabled and chronically ill youth, working class youth, or youth activists. These platforms are then used by law enforcement to monitor our interactions and efforts for advocacy. These places then stop being spaces where we can express ourselves and connect with people, and instead become spaces of censorship, paranoia, and mistrust.
Mistrust can be remedied through knowledge, through transparency and communication. The current lack of transparency prevents dialogue between police and the community and makes us objects of surveillance and suspicion. It takes away our agency and input into how we're treated. If youth know what tools the police are using, we would feel safer in interactions with our peers.
We want City Council to require NYPD and all its subdivisions to be transparent about the surveillance tactics and technology it uses and create dialogue with community members by opening up purchases and contracts for public comment. We support the idea of mandatory surveillance impact and use policy and suggest that it also include data disposal practices. We also suggest that it be written at a third grade reading level so that it is accessible to the majority of New Yorkers.
We also ask that Council determine what consequences will be enforced if surveillance technology is purchased without following these processes. Finally, we want NYPD to obtain external approval for surveillance technology purchases. Without this, there is no real accountability on their methods of surveillance.
We believe that these steps would, in combination with our other recommendations, dramatically improve the climate around privacy and surveillance for all New Yorkers, particularly young New Yorkers.
Thank you for hearing our testimony today, for taking our perspective seriously, and for holding this hearing on the Post Act. We hope that our testimony supports you in taking action on this serious issue.
Thank you to the Youth Board. Thank you.
Am I on now? Can you guys hear me? My name is Elizabeth Daniel Vasquez. I'm the Special Forensic Science Counsel at the Brooklyn Defender Services. Just to drill down a little bit on what that means, my role with the Brooklyn Defender Services is to monitor and stay on top of emerging scientific, technical, digital, and surveillance technologies, to educate the trial lawyers in my office about the technologies that are out there, and to analyze the legal as well as technical issues that are raised by those technologies. I want to thank the committee, Councilmember Gibson, and also the chair for having this hearing today and for inviting this testimony. I had prepared comments, but after listening to the NYPD, I have just a few points that I would like to make that are separate from what I had prepared. I have submitted written testimony that addresses other concerns. The chairperson Richards pointed out the New York Times article that came out last night about the technologies that are being put forward in China. And as I was reading the article, I engaged in a thought experiment that was both horrifying and helpful, which was to read the article and replace the city name with New York City and see if it struck me as wrong. When I got to the end of the article, there had not been a point through reading it that I encountered a circumstance or a technology that was being used that I felt was not being used in New York City. The thing that the article focused on was the emergence of a network of the surveillance technologies. What it was focusing at was the use by the police forces of technologies that overlap and speak to each other. And what we are seeing here in New York City with the domain awareness system is New York Police Department's creation of a system of collection, aggregation of data, and use of surveillance technology that approaches that same concern about a network. I know that the NYPD commissioner spoke about having a use policy for the domain awareness system. When they speak about the domain awareness system, they are not getting down to the granular of what the domain awareness system can actually do and what it aggregates and collects. And they spend a lot of time talking about the video camera monitoring, but what the domain awareness system actually does is it aggregates all of the data that NYPD has access to. What that means is the domain awareness system includes every type of reporting that the NYPD creates, along with the video cameras, along with the license plate readers, along with the various sensors that are around the city, and then puts on top of that algorithmic thinking to understand what that data might mean. So I want to give an example related to license plate readers and how the domain awareness system works with that. What we know, because the New York Police Department has been trying to sell the domain awareness system to other police departments around the country, is that they have advertised the fact that the domain awareness system includes a time and place pattern algorithm that allows them to go through the 5 years of license plate reader images that they have and to work out where a particular license plate might be at a particular time on a particular day based on where it has been previously. The last point that I want to make that stems from that and some of the comments that the commissioner was presenting to this body is that the commissioner seemed to suggest that the thing that distinguishes us from China is the Fourth Amendment and the role of discovery in the criminal process and the ability of criminal defense lawyers to learn about these technologies and argue their constitutionality in court. The problem is that we aren't hearing about these technologies in discovery in our criminal cases. I'll give you an example. Facial recognition technology is a hot button item right now. There's a lot of reporting that is out there about the use of facial recognition technology. Because of the work of Claire Garvey at Georgetown and the FOIL litigation that they engaged in, it came to light that the NYPD has been using facial recognition technology for 8 years now. I can count on one hand the number of cases in which my office has received discovery related to the use of facial recognition technology in a case over that time period. The NYPD is reporting thousands of arrests using that technology, and that technology is not being disclosed in our cases. So to the extent that the NYPD wants to say that the check on their use of this technology is the Fourth Amendment in our litigation in our cases, that information is not reaching us through discovery, and that is why this bill is so important. We thank Councilmember Gibson for sponsoring this bill, and we do ask that it be passed expeditiously.
I'm Alice Fontier, the Managing Director of the Criminal Practice at the Bronx Defenders. I also submitted written testimony, and I do want to follow up on what was just said with a little bit more detail, because I think it is incredibly important, and I was heartened when this hearing started with a discussion of the New York Times article last night that was released last night. And I think it is important to note that that article began by saying, China is ramping up its ability to spy on its nearly 1.4 billion people to new and disturbing levels, giving the world a blueprint for how to build a digital totalitarian state. Chinese authorities are knitting together old and state-of-the-art technologies, phone scanners, facial recognition cameras, face and fingerprint databases, and many others into sweeping tools for authoritarian control, according to police and private databases examined by the New York Times. Now, I want to read to you from a NYPD statement about the Domain Awareness System. They say that the Domain Awareness System, DAS, is a network of sensors, databases, devices, software, and infrastructure that delivers tailored information and analytics to mobile devices and precinct desktops. Originally designed for counterterrorism purposes, the DAS has been modified for general policing and is now deployed across every police precinct in the city and on the smartphone of every officer. I ask you how that sounds different from the Chinese totalitarian state in any way. It is also, the commissioner repeatedly referred to DAS and their statements about its use as a success in their transparency. That is misleading to the point of being laughable. What is on the NYPD's transparency is a statement about the privacy use that ties together private and NYPD cameras, nothing more. But what they have said about DAS, because DAS is for sale, they developed this with Microsoft and are selling it to other police departments, and they have sought awards for this system. So there is public information about DAS when they try to brag about it. And what the NYPD has said is that it includes all cameras, including stationary, dash cam, body camera, and some private. To put that in some perspective, when the NYPD testified in the body camera hearing just a few weeks ago, they stated that they have 8 million body cam videos alone. So think about the amount of video that is in this system. That also includes license plate readers. The NYPD reports storing over 2 billion records and has stated publicly that they can track any license plate in New York City historically, in near real time, and then using algorithms predict where that car might be going. It includes shot spotters, radiation, x-rays, and other sensors, real-time crime center data, and the real-time crime center data that is available on every smartphone by every officer in real time includes more than 5 million New York State criminal records, parole and probation files, more than 20 million New York City criminal complaints, arrests, 911, 311 calls, and summonses spanning 5 years, more than 31 million national crime records, and more than 33 billion, with a B, other public records. And then they say there's just a catch-all for other databases, whatever that may mean. We do not know the answers to what these are, what a police officer in real time can access, because there is no transparency. And more importantly, the DAS is linked through facial recognition systems, fingerprints, and is searchable by any number of inputs such as name, address, or phone number. The full information on the DAS, the billions of records, are searchable through any of these means and available on every smartphone. Add to this that the smartphones that are standard NYPD equipment are now all biometric, meaning that an officer in the street has the capability to scan a fingerprint and then search DAS using that scan. They also have the capability to take a photograph and search DAS using the facial recognition system with their smartphone in the street. Do we know if NYPD is doing this? No. But we know that the technology is capable. That is a question that must be answered. Now, in our cases, we now receive DAS reports on all people involved in the case, including witnesses. However, we receive very little or no information about any of the other specific technologies. And when we do have like the handful of cases in which we see that any of these technologies were used, the NYPD and the district attorneys jump through hoops to make sure that these never see the light of day in court. I want to give you one brief case example in which we actually did manage to receive some discovery so that you can see what I am talking about and why we need things like the Post Act as a starting point, because these cases cannot be challenged in a case-by-case basis in criminal court. Our client, who I will refer to as LR, was arrested and charged with robbery. The charges stem from an incident in which a person walked into a department store, took socks, and then was alleged to have threatened the store's security officer with a knife as he left. 4 months after the alleged incident, LR was arrested. We learned from the DA that our client was identified using facial recognition. In this case, the police captured a still image from grainy surveillance video and ran that photograph through the facial identification system, the FIS. The FIS produced some number of possible matches. The system is programmed to produce up to 200 possible matches in every case. LR was one of those photographs and was selected by the officer in the FIS unit as the best possible match. The detective working the case then took LR's single prior arrest photograph and sent it by text message to the store security officer. In court, the prosecutor argued that any information about the FIS was not relevant because the prosecutor did not plan to introduce it at trial. The prosecution's plan was to have the security officer come in and make an in-court identification, meaning they would ask the security officer to point to the man whose picture he had been sent by text and was able to keep all the way up through preparation of trial, who was also the man who would be conveniently seated next to defense counsel. That would be the identification, and the prosecution would never mention facial recognition. The NYPD, for its part, filed motions to quash the subpoena for information about the FIS, arguing that it was proprietary information and should not be disclosed in court. Through these means, the NYPD and the district attorney prevents anyone who has been impacted by these technologies from challenging them in court. In this case, instead of the judge actually granted a hearing on these issues, and instead of actually litigating these and let any of this see the light of day in court, the prosecutor offered our client a misdemeanor and time served. He was facing a minimum of a 5-year sentence if he was convicted after trial. So of course, he took that and walked away. You should also know that in this case, LR's son was born 2 hours after the sock thief was in the department store, and LR was in the hospital with his son when he was being born. Our client also has a twin brother. These facts alone should make you question the reliability of facial recognition. But because of the NYPD and the district attorney's efforts to avoid litigation, we have never been able to challenge this technology in any courtroom in this state. The NYPD must answer the questions about how this technology works, how they are using it, and whether it is reliable. People are being prosecuted and sent to jail because of these technologies. In the rare case we actually receive information that the NYPD employed one or more of its many available digital surveillance or identification techniques, we still cannot challenge it in court. We say that we value our freedom. We say that we fear a totalitarian state in which the police have unchecked power, in which the police are able to surveil every one of us on an ongoing basis. Yet we have done nothing to check the authority or even confirm the techniques used by the NYPD. We know the technology exists. We know the NYPD has it. We know the NYPD uses it. We cannot be content to let the police develop, maintain, and use any and all surveillance techniques that they see fit. The Council must pass the Post Act. It is not enough, but it is a step in the right direction.